we are setting the pace for our discussion with the Minerals Commission, as we do every Wednesday morning. Today we are looking at the laws relating to mining and the Offences and Sanctions as enshrined in the Mining and Mining Amendment Act 2019, Act 995. Last week, we discussed the rationale behind the National Alternative Employment and Livelihood Program for illegal miners and the measures government has put in place to tackle the negative effects of illegal small-scale mining in Ghana. So today we are looking at offences and sanctions, and in the studio to help us delve into that matter is Mr. Josef Iroko, Manager, Legal Department of the Minerals Commission. Welcome, Mr. Iroko.
Thank you for having me.
Great. I hope that you've had a good time. You listened to the discussions and you also saw the place you visited.
Yes.
I wonder if you have a few thoughts to share before we move into the substantive.
Well, I guess the gentlemen had very interesting points that they delivered when they were making their presentation. So, yeah, very interesting. But regarding the pictures, I think it's one of sadness. But unfortunately, this deja vu, this was the first time you are seeing this. So we really hope that your spotlighting will help. We ensure that help will come their way for that to happen. Yes.
Okay, let's move on to our main topic for today, offences and sanctions. What are some of the things that constitute offences in the Mining Act as we have it? Okay,
thank you. We have the Minerals and Mining Law of 2006, Act 703. Now, there are various offences in the law, but there's a particular section, sections 81 to 89, that is specifically focused on offences for the small scale mining sector. So that's what we will be going through this morning. Now, these offences sections have seen a number of amendments over time, mostly because when they are implemented and we see challenges, we tend to try and amend so we can basically be in line with the challenge that we encounter. So over there have been amendments as and when the need arises. So the last one was made in 2019, which is the Minerals and Mining Act of 2019, Act 995. Physically just amended the offences section so it can be into modern times. You recall that was also the era when the fight against galamsey was quite topical. Everybody was talking about it. The country wanted action to be taken. So the offences and penalties have to be amended so they can complement government's attempt at dealing with the menace of illegal small-scale mining, which we probably call as galamsey. Yeah.
But you're still having to. What is an offence under the law? What are some of the things that, when you engage in, the law would say you've committed an offence?
Okay, so a number of them have been done, and I would like us to. Some of them have been projected on the screen. So you see that in the law, you are not permitted a Ghanaian. Now, the small-scale mining sector is for Ghanaians. Foreigners are not expected to take part in it directly or indirectly. So when you are a Ghanaian and you help a foreigner, for instance, to engage in small-scale mining, it's an offense. Now, as I mentioned, the previous law has been amended, and we need to look at the comparison to see how the amendment has taken place. If you look at the old law, the fine was 2,000 penalty units, which is a minimum fine. The maximum fine was 20,000 penalty units. And it could be jailed for 5 years, minimum, 10 years maximum. But now the law has been changed. The minimum fine has been enhanced from the previous 2,000 to 30,000 penalty units. The maximum fine being 100,000 penalty units. Now we need to understand what the penalty unit means. Penalty unit means, in the Fines Act, a penalty unit is 12 cedis. So when you go to court and you are fined, they say 10,000 penalty units. They are 12 times 10,000. Now in the new law, the minimum fine is 30,000 Ghana cedis. And if you do, they do 12 times 30. That is, then you get the
30,000 penalty units.
One penalty unit is 12
cedis. Okay.
So when you are convicted and you pay 30,000 penalty units, basically you are paying 360,000 Ghana cedis. At first, the fine was 2,000 penalty units. So you can see the difference in terms of how high.
So a huge jump.
Yes.
So if a Ghanaian were to help a foreigner or for a company to engage in small-scale mining, they are liable to pay the fine of 30,000 penalty units,
yes,
which is pegged at 12 cedis per unit.
Yes.
Got it. And which other offences
well, there are a number of them. For instance,
cover?
Again, we have provision against the use of champagne. You know, the champagne, the equipment that they are used to mine along river bodies. The law has prohibited the use of those champagne or any other equipment to mine against river bodies in a mining operation. Now, this is a new provision in the law because we didn't have it previously, but now it's been inserted in the law, and it is that when you are arrested and you are convicted, there's a minimum fine that you pay, which is 50,000 penalty units. That is 600,000 Ghana cedis. That's the minimum fine. Then you pay, or if you impose the highest fine, is 100,000 penalty, which is 1.2 million cedis. Or you could be jailed. The judge can give you a minimum sentence of 15 years, or can impose the highest sentence of 25 years if he thinks that the offense is quite serious, or he can impose both a fine and a custodial sentence. So that's one other new provision that has been made in the law. So you cannot use a floating platform or any other equipment to, if you like, for small scale mining in a law. Now in our law, usually we don't give mining rights to people near a water body. Usually we give a 100-meter buffer zone, even from forest reserve and all that. So you are not permitted to actually mine in or along a water body. So when you are arrested and convicted, this is the fine that the new law has imposed. You can be fined or you can go to jail. Now in the new law, what has happened is that the law has imposed the minimum amount the judge or the court can impose. So if you are fined, the judge cannot give more than 50,000 penalty units. If you are sentenced, you cannot go beyond 50 years. In the previous law, there is a minimum prison term, but not
a maximum.
We have a maximum prison term, but not a maximum. Okay. So if you are, assuming this is 2 years, and just gives you 1 month, he or she would have fulfilled.
Would still be operating within the law. Of the law.
But now, because of the effect of the damage that we are witnessing from illegal small-scale mining, the law has changed. There's a minimum the judge can impose, and it is 50 years. Can you imagine spending a minimum of 50 years in jail? That's quite a lot. So
15 years.
Yes, 15
for
years.
Any of the offences.
No, for using
the champagne
in or along a water body, or
mining in a forest reserve.
Well, forest reserve, that really has not been provided for specifically, but then these are in near or a river or a water course. Forest reserve, that has been banned now. So when you go into it, that can also be illegal mining, and there's a sanction in the law that would deal with that specifically. Yes.
So I always ask this question. All these offences are there, and yet we see people engaging in the illegality. There's an active campaign against illegal mining.
Yes.
How is this law being used to back that campaign? Okay.
Now, it's true, sometimes we have the laws and the implementation is weak. I think that because Christ came and then preached and went away, and then people are still pushing that we should, if you like, repent from sin, and sin still happening, therefore Christianity should end. So the law must be there to serve as a deterrent to those who want to involve in. In fact, the intention of the law is to make the illegal small-scale mining a high-risk business. It may be there. We may not be having the kind of prosecution that we want, but once it's there, if you are going to, you know that when you are arrested, serious sanction that will be imposed on you. But beyond that, we're also looking at ways of engaging stakeholders. So in April this year, we had the training for judges from certain mining communities, so they can be abreast with our law. So when cases like that come before them, they know the sentences to impose. We have one plan for the police because they also prosecute some of these cases with that.
So the Minerals Commission does not have the power to prosecute?
No, we don't. Our law does not permit us to prosecute on our own.
So the way to go is to bring the offenders to court?
To court through the Attorney General and the police. Don't forget, the Constitution is the Attorney General who has the power to prosecute criminal matters, and these are criminal matters. So when this happens, our officers on the ground will report to the appropriate courts, and then they are then empowered to take action appropriately. We don't have the power to do prosecution as at now.
And when it comes to the collaboration between the Commission and other agencies, you describe the relationship with the police? Are you content with how they've handled the issues or the cases that you've identified, you've monitored, you've picked people up presumably, and you've sent them to the courts? Are you content with the collaboration that exists between you
I would
and
say there is more room for improvement, but then we are also intensifying our collaboration. As I mentioned, we intend to train all of them. We've done for the judges, the police prosecutors are next, and we hope that out of this, then we can enhance their capacity and ability to be able to effectively prosecute offenses under the law.
I just want to find out the main law that regulates the mining industry that's the 703.
Yes, the Minerals and Mining Act of 2006.
And you identified lapses in there that necessitated an amendment.
Yes.
What challenges did that present you?
Challenge in terms of
what challenges were you presented with within the old law that necessitated the amendment, and how is it helping you to fight these offenses?
For instance, in the parent law, the High Court were only called that were given the power to prosecute offenses. When the law was implemented, we saw that in the mining areas at the time, there were more circuit courts than there were high courts. So what should we do? The law was amended to include circuit court so that we can have accessibility to the court, so that we'll be in a position to be able to effectively okay, that is one. Then, of course, as I mentioned, when the guarantee issue crop up again, the old law, the punishment was not strong. For instance, somebody can be, you are fined, 20,000 penalty units. It wasn't money for those who really were making money from the illegal small-scale activity. We needed to enhance the penalty so that when you are caught, the punishment for this will be high, will be high for you. You know, so so the court issue is very important, because with that accessibility to the court, you really cannot even enforce the law. So the circuit courts were added to the list of courts that can prosecute the matter, so that we can have more courts being able to try offenders. Then, of course, we also realized that most of our many people were not even aware of the law. Even after they were amended, they were not aware of the law. That's why we started doing the collaboration that I spoke to. There were other changes too. For instance, there's now a provision in the law for a foreigner. Now we realize that, as I said, foreigners are not permitted in small-scale mining, but we continue to see evidence of that on a daily basis. So now when a foreigner is arrested, in fact, in the new law, some of the stiffest punishments are reserved for foreigners or their Ghanaian collaborators who will be involved in illegal small-scale mining. So now, for instance, when you are convicted, the law is that you will be jailed, then you'll be deported after you have served your jail. So a foreigner, if you are arrested now, should be taken through court. When the court convicts you, then you are sentenced and imprisoned. It's only when you are finished serving your sentence that you'll be deported out of the country. That wasn't the case in the previous law, for instance. So that's one other new change that was also added. Then the old law really have provision for those who use excavators and equipment in the mining contrary to law, so without permission. So now there's provision for that in the law. We have also made it clear in the new law.
So it seems like as you moved about on the field,
the
more infractions that you noticed or identified,
we tend to amend.
Sent those to the team to be included in the new law.
So we do provisions, we do proposals. It's taken through the process, and then the department, they look at it and send to Parliament for it to be passed into law.
Okay, let me get this clear. Once a person is identified to have flouted the regulations or to have committed an offense under the Minerals and Mining Amendment Act 2019-995, as I'm seeing here, and the 703 that you've mentioned as well, what's the procedure to get the person to be brought to justice?
Okay, just like any criminal matter. So report is made.
By who?
Okay, so we have officers in the various districts.
That's the Minerals Commission.
Yes, these officers who, for instance, are empowered to report. Then, of course, a citizen who also realizes somebody is doing something illegal has a right to lodge a complaint at the police station. Then you are taken through the process of, just like any ordinary, normal reportage of a criminal matter to the court. So then the person is arrested, then they are processed for court, and if they are convicted, the punishment and the penalties are then imposed. So our officers really are the first point of call, but every citizen is also entitled to help police our mining industry by reporting any infraction of the law to the appropriate courts for action to be taken.
What's the position of the law on seized equipment?
Okay. So the law is that when you are arrested, any equipment or product from illegal mining that is seized must be taken to the police station. Then if you go to court and there's a trial and you are convicted, the court is under the obligation to seize the equipment or the product from illegal mining. When that is done, the minister by law is empowered to allocate this seized equipment or product to any government institution that will require it. When this allocation is done, then the minister is required to publish in the Gazette the list of those beneficiary agencies that have received the equipment. So first step, arrest, seizure of equipment, then trial, conviction, forfeiture, then allocation, then publication. So these are the steps outlined in the law.
Okay. I would want, as we begin to wrap up, how do you think the Act has been amended has impacted the operations of small-scale miners and even large-scale when it comes to getting people to abide by the tenets that the law provides? Has it helped you to bring the rate of illegalities down? And what more could we do to keep the numbers up?
I'll say, and don't forget, this is not a process. It's not an event, it's a process. It is something that is ongoing. So as and when they are arrested, the police are empowered to use the law. Now, so side by side with this is what we have spoken about earlier on this studio, the Alternative Livelihood Project, and the various other attempts by government to regularize the system, to make the system easy. Because one other reason why illegal sponsorship happen is that people say it's bureaucratic in terms of the processes. So we are basically we've gone online, for instance, so you can apply online. These are steps that we think will complement the law. So even as we are enforcing the law, also make sure that on our side we are making the process easier for applicants to be able to go through easily. We think that when that happens, the recourse to illegal small-scale mining will be reduced, if not completely eliminated. But we think the law is deterrent enough, and continuous engagement with prosecutors, with the judiciary, and even the citizens alike, for instance, what I'm doing today, we think goes a long way in ensuring that this law is able to be able to achieve the intended objective. So on the whole, I think that it's a new law. This was passed in 2019. So we will say the jury is still out, but I think that the implementation so far, in my view, has been good. Yes.
Thank you so much, Mr. Iroko. Mr. Josef Iroko is the manager, legal department of the Minerals Commission. He's been talking to us about the laws relating to the offences and sanctions as captured in the Minerals and Mining Amendment Act 2019, Act 995. So it is illegal for a Ghanaian to help a foreign company to engage in small-scale mining. It is illegal to use certain kinds of equipment in small-scale mining, and all those attract some fines as well as terms of imprisonment, or both in some cases, depending on the severity. So that's what Mr. Iroko has been here to talk to us about. Thank you so much for adding your voice to this.